This is a lecture for my administrative law class, and that may also be useful for related classes like statutes or legislation and regulation. And this is a quick overview of our section or chapter or unit about the availability of judicial review. My goal here in this video is to give you a kind of a roadmap of what we're going to talk about in this chapter, so you can see in advance of how the materials are going to fit together. You know what you're supposed to be learning about by the end of the chapter or have learned about, and maybe it will help you know what to watch for or take notes about, or make sure you understand when you're doing the flashcard. Some students may find it useful to use this video as a very quick, simple recap at the end of the chapter to make sure that you didn't miss anything important. So here we're talking about judicial review of agency actions, and when is judicial review even available? And again, in my administrative law casebook that I'm using, this is its own standalone chapter near the end of the course. So what are we going to be talking about in this chapter? First, we have some cases about statutory preclusion of judicial review for certain agency actions. And as you can imagine, this raises some constitutional issues that go to the US Supreme Court. Can Congress just write into a statute that no court is allowed to review or reverse an XYZ agency when they take certain actions? And Congress does this from time to time. More often, they actually spell out that they want more judicial review to kind of keep the agency in check. But sometimes a favored agency, they will try to preclude judicial review statutorily. And you'll see, we're going to do a couple of cases about how the courts wrestle with that. Secondly, we're going to talk about this very important issue of judicial review for agency inaction. So when can the courts intervene when an agency hasn't done anything, but that's the whole complaint, is that the agency's not doing anything or not doing what it seems like they were supposed to do? I hope you can see, even based on your first year courses, that omissions and actions are treated differently by our legal system, and we are going to have the judiciary responds differently to agencies who have done nothing at all, who are just sitting on their hands, so to speak, and not taking action. Then we have a group of cases about the timing of judicial review. And even though this is at the end of the course, when you're in practice as a lawyer, this ends up being really important, an issue that comes up all the time. So when do we have a final agency action, or when is the agency action final enough that we can go into court and the court will say, this is actually something that we can make a decision about. We have an official agency action, as opposed to something that's still in process, because the courts don't want to meddle or intervene when the matter is still kind of pending with the agency. So this is a way to, some of these timing of judicial review issues are a way to preempt the courts from preempting the agency. We have a related concept of ripeness. When is an agency action ripe for judicial review? And then a requirement of the exhaustion of administrative remedies. And one of your takeaways from this is going to be that these three concepts about timing of review overlap a lot, and the courts, actually judges, can get them mixed up or conflate them. But exhaustion of review, ripeness, final agency action are very important issues, and we're going to do some cases about those. And then standing, which you probably got a little bit of exposure to in your first year constitutional law course. And so, but here we're talking about specifically when you have standing to challenge an agency action or standing to sue. And when, again, sometimes we have statutory issues where the statute gives citizens a right to sue, and it seems like that creates standing, and sometimes the courts say that's not enough. We need something more than the statute in order for this person to have standing to bring this action. Okay, and that concludes our quick overview of the availability of judicial review chapter in our administrative law course.